You know how sometimes a tiny little neighborhood dispute, something about pets or parking, can suddenly blow up and collide with the full force of the law? You might be surprised. Today, we're diving into a case that did exactly that. And trust me, the outcome has some pretty big implications for anyone living in a community scheme. It all kicked off with this number, 250 Rand. I mean, not a huge amount of money, right? But as we're about to see, it became the price tag on a very big and very, very wrong assumption. So this brings up a pretty wild question. How in the world did a simple fine for dog poo escalate into a legal showdown that would end up reinforcing the rights of thousands of people? That's the story we're unpacking right now. All right, let's start right at the beginning. Our story kicks off with that R250 fine and what is basically a classic case of he said, she said. Okay, so picture this. We're in Sea Point at a complex called Victory Court. A landlord, Kobe Bar BB, gets his levy statement, and there's a surprise on it, a $250 fine. The charge? His tenant's dog was accused of leaving a mess in a shared area. Seems simple enough, right? Well, here's the twist. When Baribi pushed back and asked for proof, the body corporate admitted they didn't have any. No photos, no eyewitnesses, nothing. Their entire case was, and they actually said this, an assumption. Why? Just because his tenant's dog was the only one they knew of in the building. So the whole thing was based on a guess. Now, to really understand why you can't just find someone based on a hunch, we need to take a quick look at the actual rulebook for these kinds of communities. So there's a good chance you might live in what's called a sectional title scheme. The concept is pretty simple. You own your apartment or your unit, but you share the common property, the gardens, the hallways, the pool with everyone else. And who manages all that shared property? Well, that's the job of the body corporate, which is really just a formal name for all the owners working together. They're the ones who have to follow a specific law, the STSM Act, and make sure the building's rules are enforced. So what happens when the very people enforcing the rules don't follow the rules themselves? Well, that's where a referee comes into play. It's called the CSOS, the Community Schemes Ombud Service. The easiest way to think of it is as a specialized, low-cost referee just for community living. Its entire purpose is to resolve disputes just like this one, fairly, and without anyone having to face the massive costs of going to court. And the process itself is surprisingly straightforward. If you've got a dispute, you just lodge an application. An adjudicator then investigates, looks at the evidence from both sides, and then issues a legally binding order. This is the exact path our landlord, Kobe Barbie, decided to take. So what happens when a case like this goes to the CSOs? Let's look at the ruling not just in the dog poo case, but in another really similar dispute, because when you put them together, they reveal a single, powerful principle about fairness. Okay, so in the first case, the fine for the dog was ruled unlawful. Why? A complete lack of evidence. Then, in a second similar case, an owner was fined for having a filing cabinet on his balcony that the body corporate just found, well, displeasing. That ruling was also overturned as unlawful because the rule was just being applied unreasonably. Both cases point to the exact same powerful lesson. Any decision has to be based on hard evidence and a fair application of the rules. The adjudicator in the Victory Court case put it perfectly. And this quote, it really gets to the very heart of the matter. You can't just lump old complaints together or fine someone because you suspect they did it. Every single accusation needs its own evidence, period. So what can we all learn from this whole thing? Whether you're a resident or you happen to be serving on a body corporate, there are some key takeaways from these rulings. For residents, the message is crystal clear. You have the right to challenge a fine that feels unfair. And remember, the burden of proof is on the body corporate, not on you. An assumption is simply not good enough. And if you need to, the CSOs is there to give you an affordable and accessible path to a fair hearing. And for all the body corporates out there, the lesson is just as important. Process matters. Every single decision has to be fair, lawful, and based on credible evidence, not assumptions. Because as these cases clearly show, if you don't follow the law, your rulings can and will be overturned. And all of this leaves us with one final question to think about in our own lives. When you look at your own community, are the rules built on a solid foundation of fairness and evidence? Or are they based on simple and potentially costly assumptions? It's a question worth asking. Thanks for digging into this with me.